Yes.
May I please, your Lordship? Lordship, I beg to mention item number 6 of daily list, Lordship. Lordship, my senior Mr. Y.S. Marland is not well, so he could not come to the court today. Kindly, Lordship, agenda matter for today, Lordship.
Okay.
And maybe fix it next week, Lordship. Next week, Lordship.
Just after a week, as paid for by Mr.
T. Thakuria, Lordship.
Thakuria, counsel for the appellant,
Yes.
Miss
Madam.
B. Bhuya, senior counsel, and the APP for the state, along with our instructing counsel is present.
Lordship, if possible, date may be fixed, Lordship, next week.
We'll list in the next one. Okay. Yes.
Obliged, Lordship.
May I please, Lordship? I beg to mention item number 5. Kindly taken up the matter after 3 weeks. My senior is in hospital.
Adjourned frequently.
No, madam.
No.
No, there is an order
Huh.
that similar matters are pending before the Supreme Court.
That's
On that ground.
On that
That is why it is being adjourned.
That was
Okay.
adjourned 3 years back. But yesterday we were informed that the respondent number 1 has expired. So we are awaiting some documentary evidence. Let it be taken after 3
After 3
weeks,
weeks.
because the trial has been abated against this person.
Miss
GD Chaudhary.
E.D. Chaudhary, counsel for the appellant,
Appellant.
submits that similar matter is pending for adjudication. Can I
Appeals against similar order passed in this.
appeal against the impugn order?
In fact, the Supreme Court order has come, I can place that.
Next question. Mr. B. Prasad, Learned Counsel for the
Respondent number 1.
Number 1. I think this sole respondent.
My lord,
So-
my wife was also in made a party here, but she is not any case.
Okay. Respondent number 1. Submit that as per instructions received by him, the respondent number 1 has expired, and therefore the prosecution against him would abate. How he is awaiting the written instructions and death certificate. And he also pays for adjournment. Fair is allowed. Instance adjourned today, list after 3 weeks.
Highly obliged. May it please, your Lordships. Lordship, I'd like to mention item number 4, my lord. I have the concern of the other side. This matter may be taken up after a week, my lord.
For a week.
Lordship. Item 4, no? Item 4. On behalf of Mr. A.K. Bhuya, my lord, for the appellant.
On the prayer made by Ms.
B. Bora.
B. Bora, counsel for the appellant. The matter stands adjourned today. Ms. S. H. Bora, learned APP. And Mr. M. S. Rajbhoy, learned counsel for respondent to the present. List after
After a week, my lord.
the week.
Deeply obliged.
May I please, your lordship, I beg to mention item number 1.
Item 1.
Item 1. My humble prayer is to kindly adjourn the matter for today as my senior counsel is out of station. We have already submitted the adjournment petition.
On the prayer made by counsel for the appellant, the matter stands adjourned. Ms. S. H. Bora, learned APP is present. List after
Date 22 January.
list on 22/1/2024. Okay.
Oh, 22, then 23 maybe. 22 is
not
evaluated,
22,
oh,
not 23, 24 then.
24.
Okay.
Daily list item 1.
Item 1 is adjourned.
One is adjourned.
Item 2.
I thought this matter may be passed off for the time being
Item
because
2.
my senior is on the way.
In the meantime, we'll just have the facts from the land APP.
Lordship, paper book is also not with us, so we are not also ready also.
Report 9.
Yes, Lordship, I have, but we have to go through Lordship. Shamla,
There is a,
Shamla.
Ms. Bharat, there is a difficulty
Lordship,
because we both have single bench.
yes,
We can't start the single bench unless this is.
yes,
this
Lordship,
breaks.
I do understand.
Correct.
Lordship,
So we can adjourn for half an hour
Lordship,
at best,
Lordship,
correct?
yes.
We'll resume at 11. There's one more item. Item 3,
Yes. I think nobody is appearing on behalf of the petitioner, Lordship.
Huh?
I think nobody is appearing on behalf of the
Nobody is
petitioner.
here. So we resume at 11 then.
Lordship,
Item 2 of division bench.
But inadvertently, my junior made a mention that actually that my matter has been listed in a single bench at one. Item number 1 was wrongly mentioned. In fact, my item is that before your lordship in the single bench, Miller.
We'll give item 1. Oh, single bench one. Oh, acha, okay.
আমরা ভুলকে যে মেনশন করেছিল এটাই করছি।
APP is present. However, there is no representation from the learned amicus curiae for the appellant. Next, this being a jail appeal of the year 2018, the registry shall appoint another amicus curiae from the notified list after taking consent and provide the newly appointed amicus curiae a copy of the photocopy of the paper book. List in the week commencing 29/1/2024. That this ought to be brought to the notice of the AOJ Criminal Appeal Section.
Item 3.
Last two occasions, appealant. Basically, this is dependent on the evidence of PW1,
Yes.
correct?
Yes.
What to do, the lawyer is not there.
Yes. They adjourned for today. So.
The appellant remains unrepresented. For the third time in the row. I on 28/10/2021, 24/3/2023, as well as today. Next one, Ms. S.H. Baral, and the APP is present. Next para. The registry shall send a notice to the appellant. In the concerned jail where the appellant is lodged, to inform him that he is unrepresented by his engaged counsel, so as to enable him to do to make an alternative arrangement prior to the next date of listing. So the appellant is put to notice that in the event he is unable to engage a learned counsel to represent him, he can avail legal aid for which he may apply before this court to the jailer concerned. Next para, the court also reserves its right to appoint and learned amicus curiae to represent the appellant. To ensure ensure that the appellant is properly represented when the matter is heard on the next date. Next para. The concerned jailer shall inform the registry about communicating of today's order to the appellant. Next para, list on one to 2024. Over the time by let this order be brought to the notice of the AOJ Criminal Appeal Section.
Lordship, may I submit an
Yes.
extra copy of the paperwork may be submitted to us, Lordship?
To you?
Yes.
Okay. The registry shall also provide she pays for a copy of the paperwork. The registry shall furnish a copy of the paperwork to the learned APP
Flush.
And in an unusual manner, I will start with an adjournment motion. Your matter will be taken up at 2. This is item 1. This file went to my residence. I forgot it there. So I'm getting it. At 2 o'clock it will come. But you can still proceed with your argument because I'll make notes in the meantime it will come. I don't have the brief right now, but I can follow you since I had taken my notes. No, since I have taken the notes, I'll remember it. Huh.
So far that judgment is concerned, that judgment went to the Supreme Court also, and Supreme Court has. Precisely the judgment was that, so far the Assam land review regulation is concerned, it is a bit defined from the rest of the section. Because the land review regulation itself is under section C9, the land review regulation itself makes a provision that the landowners are the absolute owners of the land. And they for the heritable and transferable rights. So so it was the nature of this judgment, it was that if the Patta is granted in your favor, then Patta will confer you right that you need. And so far the mutation entries are concerned, we cannot ignore the mutation entries totally. Mutation entries totally.
Just a moment. Just a moment. There are 2 IAs. Huh. No, because then you will be free. She's an APP. She will be free. There are 2 criminal matters, tied up matters with me. Just 5 minutes. Yes, what is this IA for? Item 3.
Single bench item 3.
This, in fact, last time I was disinclined to entertain this IA. You see, the reason I have assigned in order dated 18/10/2023. You see, the informant has filed this application saying that his life has been threatened. And his conduct was to go before the executive magistrate and file a 145 proceeding. Correct. So if there's a 145 proceeding, we then understand the urgency and the extent of threat which he has. So I would disincline. No, I have not passed any order, but this is an application for what you call seeking his protection. So therefore, the privacy view was that this the extent of threat which is being perceived is non-existent. So let us see if it doesn't come, then I'll pass an order in the chambers. Item 4.
I was filed for correction.
What is the correction?
Relating to the bail applications. It is already done 19 December. So I am saying to withdraw.
No, what is the correction just pointed out?
Correction, the court name was wrongly put as additional session judge, but it should have been special judicial magistrate. So just coming back.
It should be
Special judicial magistrate.
special judicial magistrate.
First class. There are one.
Special judicial magistrate or special judge.
So they are making special judicial magistrate. First class.
Special judicial magistrate, first class, Kamru Metro. Okay. Any other correction? No, only that name of the court.
Yeah, matter is already disposed of. Matter is already disposed of.
No, I understand. That is the only correction. Okay. Page 8, correction, special judicial magistrate. Your name?
Kanyakumari Setiapukar.
Write it down. Write it down on a piece of paper. Her Miss so and so, as well as Mrs. Miss B. Bhuya, learned senior counsel, and learned ABP for the state, represented by, as assisted by Miss S.H. Bora, the learned ABP. This interlocutory application has been filed for correction of the typographical mistake that is crept in the order dated so and so. Next, prayer is allowed. The reference to so and so additional sessions as so and so shall be now read as special judicial magistrate, first class, Kamru Metro, Guwahati. This order shall be read together with order dated so and so, passed in BA so and so. Okay. I'll pass orders in chambers. I don't want to keep Mr. Dasgupta waiting. Yes.
So basically, it refers to me, that here is a dispute between two documents. One Jamabandi was issued in the year 1972, and subsequent is in the year 2002. By first Jamabandi, which was issued in the year 1972, by the, we stated that a patta was granted in my name. In favor of my mother's name here, in favor of the plaintiff's place. And subsequent Jamabandi, which was granted in the year 2002, is that here, three persons' name was entered. One of them is my daughter, and the other is the different number 2 and different number 1. So, my lord, we have challenged the subsequent Jamabandi. And there is a specific prayer in this regard. Now they filed their written statement. And in that written statement, it is their case that this Jamabandi which was granted in, sorry, the patta which was granted in our favor in the year 72 was possibly done by us. It was not with their knowledge.
জানি পাই গো। এই ফোন করে দিব ফাইল করে দিব। Yes.
Was not with their knowledge. And this conversion was made collusively in my favor, and it was not with their knowledge. That is their case. Now, look, it transpired that they have not challenged or questioned this Jamabandi which was granted in our favor in the year 1972.
1972.
72. That is probably exhibit A.
Uh, 1972 is the Jamabandi.
That is the
Entry in the Jamabandi.
whereby the periodic patta was granted in my favor.
In favor of Maya Devi. Yes.
These Jamabandi have not been questioned. They have not filed any counter claim. In the contrary, the subsequent Jamabandi which was issued in their favor, we are specifically done. And we made a prayer in our faith. Their case, before your lordship, which reflected from the written statement is that in the year 2002 or something like that, that is the plaintiff, along with the defendants, went to the office of the faculty officer and told them to enter their name in the Jamabandi. That is their case.
Please repeat again. You along with,
I mean the plaintiff.
plaintiff, Mahadevi.
With the defendant.
Okay.
That is, they have stated in their written statement.
Yes.
The circle officer to get their name entered in the label record. In other words, to mutate them. That is their concern. No,
Mr. Dasgupta, to you and Mr. Mazumdar, I have a query. Both of you can take your own time to respond to it. It's not necessary that you will answer it right now. You see, when a settlement process is on,
yes,
at that point of time, under the land revenue regulation, the authorities who are the circle officer or he is the assistant settlement officer then. He visits the site and then makes an entry in the chitta. That is one way.
section 17.
Maybe the provisions I am just now not referring. That is one part. The second part is that corrections by way of signatures put in the chitta. I have some reservations because the power of the settlement officer we understand, but parties when the settlement process is not on, then the parties going there and making entries in the chitta. That is the query. How that is being done?
How that can be done.
Yes, correct.
Yesterday, I have checked this matter, subject to rectification, because I am not very conversant with this subject. That is my limitation. Because on the other day, your lordship told me to go through this judgment. And that judgment really benefited me a lot. That is 98
GLT.
page 137. And it was there, and I also checked up. Subsequently, it went to the Supreme Court, and Supreme Court has also.
1998 4 GLT
137.
137. Yes. Huh? Ah. But that's okay, just for the citation because my slip is not there. That's why I've just written it down.
Now, look, their case is that our case, I told you that Jamaundi was prepared in the years 1972, and here nobody has produced any documents like FATA.
Nobody's done.
I have produced a Jamaundi that was prepared in the 1972, and that Jamaundi was recorded on the basis of the FATA issued in my case. And they have also produced one Jamaundi that was prepared in the year 2002. Now, so far second Jamaundi is concerned, in the second Jamaundi, my name is also included along with the other family members. There is different number 1, 2, and my daughter. I challenge that. I challenge that immediately and made a specific prayer in the plea. And they have filed their written statement. In that written statement, what they have stated that his subsequent Jamaundi was recorded at my instance. According to them, I along with the defendant number 1, 2, and my daughter went to the office of the survey officer and told them to get it rectified and that was it. That is their. Now look, how with Dhammavandu can be rectified. In other words, how there is a specific provision. That provision is section 49 to section 53 of some land revenue regulation. Here is that one should file an appeal. And the deputy commissioner or his subordinate officer will receive that application. And after receiving that application, after receiving that application, if he is of the opinion that is, your lordship will find chapter 4 of Assam Land Revenue Regulation, Part B.
It starts from which section?
Start from section 50. This chapter 4, registration,
Yes.
part A and part B. Part A is the preparation and maintenance of registration. And part B is registration.
Yes.
Number, if I go to section 50, first one, 50, subclause A. Every proprietor or landowner succeeding any estate or share, etc., that is not a share in an estate, whether by transfer or by inheritance, and obtaining possession of the same, then you will also come to skip B, C, and D. Shall within 6 months from the date of taking possession or assumption of the charge, apply to the deputy commissioner of the district on the general register of which estate is born for registration of his name as proprietor, landholder, manager, etc. So if a sale deed is executed and possession is delivered, then he can apply. And if somebody died, then his legal heirs can apply.
Yes.
Then your lordship can come to section 51.
Same thing, it's power of the proprietor registration, same provision, almost per area.
Proprietor as a simple. Then your lordship come to section 52. 52 is the sum and substance of the 52 is that
Application.
Of an application, deputy commissioner, if the deputy commissioner is of the opinion that a notice has to be issued, then he shall issue a notice to the affected person for their objections. If any. That is the president. That is the 52. And 53 is the inquiry. In consequence of the
In fact, that is not much of interest. The question, the query which I put, the relevancy is subsection 3 of 53A. 53A, subsection 3, it says petitions of objections to applications for mutation must be stamped. And therefore, the entries made in the chitta, you see, it is not preceded with a notice. And therefore, if there is no notice, then you don't have a right to object. In this case, name of the appellants were registered. And as it was not done by issuance of notice, because otherwise what happens is that when this inquiry is made, then the deputy commissioner under 53 makes an inquiry and then arrives at a finding. And otherwise, if it's no, if it is under section 52, then 52 envisages notice. In 52, you will find notice is there. The deputy commissioner shall, if he considers there is a sufficient ground proceeding with, publish a notice. Therefore, one gets a notice in 52. In 53A, if it is under 52, there's an inquiry by the deputy commissioner. If 53A, then there's a right to object. So that is why I was putting up that query, that what happens if entries are made in the chitta by people applying for which there is no notice issued. You see, there is a connection with the question which the last time also I put that. You see, when I am referring to section 3 of the Transfer of Property Act, under section 3 interpretation clause, you will find a notice described. You have a copy of the Transfer of Property Act? It is your TP Act. No, I'll give it to you. This it's relevant. Section 3 interpretation clause. Second is notice. A person is said to have notice. It is in a bracket, first bracket.
First one is removable property.
Then you'll find notice.
Then interest.
Ah.
Then register.
Hmm.
An actionable claim.
Then there's a bracket. First bracket, in the bracket, you'll find that a person is said to have notice. It is in your left side page. No, left side page. A person is said to have notice.
This that unless is something repugnant to the subject contract, removable property, instrument, trusted, etc., then you used to come to register actionable claim. A person is said to have notice. Yes, yes. A person is said to have a notice that was said to have a notice of a fact when he actually knows of that fact. Or when, but for willful
Abstinence of an inquiry.
or such, which he ought to have made, or gross negligence, he would have known.
So you see, what happens is that it has been interpreted by various judgments, like, for example, a sale deed. It becomes a public notice. Because under the Registration Act, if it is registered, it becomes, it is in the public domain. And so therefore it has been interpreted that section 3, a person is said to have notice, will have this notice in view of the registration. Correct? Now the query which I was posing was, although it is something which goes against Mr. Mazumdar, that question, but that question is that if under 52, 53, if a notice is not issued to a person who is otherwise entitled to a notice, because if there is an namzari being done, then a proprietor must know that somebody is making a claim on my land.
Yes, yes.
Correct. So let us suppose you are very happily living in your land for last 100 years. Your grandfather was there, your father was there. Now you are residing in that land. Every day you do not go to the deputy commissioner's office to make an inquiry that if some application has come for the mutation of my land. So therefore, notice is envisaged so that you put to notice that somebody is making a claim for that land. So if that, so if you now abstain from making an inquiry, section 3, or if you could have diligently objected to and not objected, gross negligence, then you are stopped from questioning his mutation.
So the 30 is all of this query is that, say, a notice has been served upon me.
Assuming a notice is served and you don't respond to it.
Responded.
Yes, so it will be gross negligence.
Where is the gross?
Here it says it is a gross negligence. Number one, it's an abstinence from making an inquiry. That you got a notice, why notice was come to me? Let me make an inquiry. So you have not done it. You have not responded to it. It becomes gross negligence. That means equivalent, it can be equivalently read with acquiescence.
I admitted your claim.
Acquiescence, you don't admit my claim, but there's an acquiescence that, okay, Mr. Mazumdar is applying, he is my good friend, I acquiesce. File is come. So therefore, you see, these are the two ways to look at this interpretation clause. So that is why my query was that in a Namjari application or a mutation of the name in the revenue records by way of a Chitta mutation, how far that can be done or that entries can be made. That is my query. This is the provision. I'm just referring to this provision. I'm putting that query. No, you see, with the,
Applied for it, muted.
no. You two go to the circle office and say that, well, please enter the name of Mr. Mazumdar. He's my very good friend. And make an entry of his name in the revenue records.
So that is permissible only.
Yes, in this case, this has been done. Mr. Mazumdar is claiming that, not Mr. Mazumdar, his client, in fact,
Through WS.
through WS is showing that this Maya Devi accompanied me and made the entry in the Chitta. So now this query is, well, how far it can be done.
Yes.
And these are the references when you are referred to 50 to 53A. I'm showing you just section 3 interpretation clause, and I'm still asking that same question. How far Chitta mutation is permissible?
That is a
Take your own time to answer it, but that is the code query.
Let's put the judgment here as we are also referring this, they've dealt to some extent in this regard. Not very elaborate, some lines are there. 98, 4 GLT 137. Paragraph 7. I read this. Under the Assam Land and Revenue Regulation, a person who is a patta holder is deemed to be a landholder, and he has permanent, heritable, and transferable right of use and occupancy in his land, subject to section 9 of the Assam Land and Revenue Regulation. And if a person, in order to establish his title, produces a patta, that must be given due weighting in as much as a patta is issued in accordance with the provisions of section 17, read with the rules, and must be considered to be a document of title.
Yes.
And this is always considered to be a document of title, patta. That has been clarified. Now further, that record of rights as provided under section 40 and 41 of the Assam, the Assam Land and Revenue Regulation shall always be deemed to be correct unless the contrary is proved. And that presumption which is attached to the record of right under section 40 and 41 must be given due weightage. And that is what was done by the learned lawyer appellate court. Now, here, your lordship's information clarified. Regarding the mutation entries. Mentees, it can be said that though the mutation entries may not be the basis of title, yet the mutation entries cannot be brushed aside, and it must receive due consideration at the hand of the court.
You see, this provision, if you come to, if you will come to Assam Land and Revenue Regulation, this is under the chapter Part D of Record of Rights.
Yes.
Now, section 39 says, effect of decision of settlement officer as to settlement. So that means a settlement process must be going on. And for a settlement process is notified by the state for a particular moza, and then the settlement process is on where field mutations can be done.
That is section
Now-
17 or not.
So whatever, but the fact is that every day these settlement operations can't go on. After that, what happens is that that is on the basis of field mutation. But after the settlement of process is closed, there is a notification issued again. Settlement officer is closed. Settlement process is closed. After that, the mutations are done on the regular basis by applying.
Oh, yeah. So during the settlement operation, somebody's name can be entered.
Can be entered.
It can be entered. But after closure
So
of the
this-
settlement
So
operation.
this 4041 is within that record of rights.
Yes.
But it is but it is the process of settlement or resumption.
Yes.
That is theoretically that is envisaged.
So what
But
is-
practically what is happening is, in your case, it has gone. There is no evidence as to whether settlement operations was going on at that point of time. The entry, Mr. Mazumdar, the Jamabandi entry is by ASO, Assistant Settlement Officer. Because that means he is not acting as a circle officer at that point of time. He is acting not as a SDC, but he is acting as Assistant Settlement Officer. That means settlement office, we will have to presume that settlement operations were on. If that be so, then it goes against you. Challenge will go against you, because if that settlement operations were on, then this judgment of will say that it has to be given some weightage. But this,
No, what your lordship wanted to convey by a lordship, your lordship, the name can be recorded in two words. One during the settlement operation. And second, after closure of the settlement operation. If it is done during the settlement officer, then somebody may go to the field or to the office of the settlement officer and can say, "Yeah, yes, you can record his name, I don't have any name." If it is closed, the closure of the settlement operation, if somebody has to enter his name, he has to follow the certain procedure as contained in the Assam Land Revenue.
section 50 to 53, A.
50 to 53.
Ah.
Section 50 to 53. That is, same thing is that if a sale deed is executed in favor of some person, the purchaser can apply. If a person dies and his son and daughter can apply, and for that purpose, these things have to be.
And there is also one provision which I forgot and I am not getting it right now. There is a provision where a landowner can apply for insertion of his wife's name. That is a special provision for Assam, where the women rights were recognized as an inherent part of our society, where the equality with women were so encouraged that a person having land can have his wife's name entered. But that provision, I'm now searching and I am not finding it, because now I don't have the energy to read this general circulars. There's a volume 1, volume 2. Huh?
Is it in the regulation itself?
No. It's in the revenue circulars called general circulars.
But then not be available in the land revenue regulation.
Those are separate revenue circulars issued from time to time, and this right was recognized. I think it's an pre-60s, where the right of women was given in the state, and that is much prior to the rest of the country. It's very unique. I wanted to find out that for the purpose of one of my what you call legal discourse I had to address, but I did not get it.
What is your query that?
No, that entry can be made.
Person concerned may volunteer to enter his wife's name in the report, though his wife is not the owner.
That is permissible.
Without exhibiting, what you also want to say, without exhibition of any sell deed or give deed,
Yes.
the person concerned straightway can approach to the revenue official and request him to put her name
Yes.
along with my name.
Yes.
There is a provision, what you also want to say.
I've in fact, I've read it and I've used it. So that's why see the circulars, but now I don't have the time and energy to read and find out.
Right.
And the second is that my bench changes quite frequently, so from criminal side to civil becomes a bit difficult. So that's all. In this provision,
What is there in the provision? There is an order. But how this order can be passed unless the rules authorize? There might have some authorization rule to make some order.
so the general circulars under the revenue under the revenue court procedures, you will find a book from authored by Honorable Justice K.N. Saikia, Revenue Courts in Assam, a yellow color book.
I have with a book of land revenue, not that book.
It's a revenue courts in Assam, where these general circulars, the government has the authority to issue general circulars, and which has the effect of law. That is permissible, and that is why it comes in a separate compilation of general circulars.
No, definitely that will be permissible unless it is not authorized by their statute. The statute must authorize to his.
No, you see, because I'll give you an example. For example, in Chapter 10 of Assam Revenue Regulation, we relates to tribal land, tribal belt. There, you'll find a limited extent of information in that act, in the Assam Revenue Regulation. But there are not less than a dozen circulars in that compilation, general circulars, where the methodology is also given. So that has to be read together with Assam Land and Revenue Regulation. And this is an authority which I read it.
Rule-making power.
No, in fact,
Statute may confer some rule-making power to the executive. How to apply these certain provisions to be present.
I don't know about that, because I read it only in that. I read it only in that Justice K.N. Saikia's book, and therefore I have a vague recollection that it can be done. But if you ask me the authority, I won't know. So that is an exception for a lady, but in this case, it will not apply. It will not apply. No, no, it will not apply in this case, so don't worry.
Now, of course, it must, the property vacation is concerned. Of course, it must be asserted that the mutation entries were done properly. That is a note of question. So, if it is a mutation, these mutation entries have to be done properly. If it is not done properly, that should not be taken into account.
But in this case, there is no evidence.
In this case,
So-
no such.
So that goes against you, because if there is no proof by both sides, then presumption is that it goes against the person who is claiming it.
Yes. Presumption is that there goes against the person who is saying. I'm not telling you. They are telling you.
No, you have challenged it. You have challenged it. So that proof of, you are asserting that it is wrong. So therefore burden is on you. After you discharge that burden, then onus shifts to the appellant.
All right. Look, here, learned appellate to the judge.
Has?
This.
Okay.
Whether that is reasonable or not, that has to be looked at. If it is, the lawsuit is of the view that yes, that is a reasonable, then probably the second thing is that will also for page 40.
Yes, I have it open.
Then let me read the entire paragraph 7. Learned counsel of the appellant submitted during his appeal hearing that the learned owner, the lower court, failed to consider that the suit has been settled in the name of the appellant as the periodic patta land on payment of premium on 23/5/2017. And so the appellant is the owner. The title holder of the suit land. On the other hand, the learned counsel of the respondent submitted that the suit land was originally annual patta land, and the right of possession of the suit land was purchased in the year 1946 by late Joynarayan Upadhyay. That is, the husband of the plaintiff, who married his mother Ganga Devi from one Vedanidhi Sharma. And since then, the same land has been possessed, occupied, and enjoyed by him. Right. It is also admitted that the defendant has been residing on the land with the plaintiff. I have gone through Exhibit 1, that is, which was issued in the year 1972. I have gone through Exhibit 1, issued on 29/27/9/2022, and found that on 23/5/72, the settlement of the fruit land measuring 8 bigha, 4 katha, 10 nesas were granted in the name of the plaintiff, and the premium for the land was also paid by the plaintiff. So it is in course of the settlement. He had applied his money. But the revenue receipt, exhibit 2-1, dated 3/2/99, 22/3/2000, and 10/1/2001, respectively, also showed that the premiums of the said land was paid on behalf of the plan. These two matters were clarified by him. He took into account by her daughter who has been staying with her mother. This was his assessment on the facts. Now, Milord, here it is very much important. Now,
Yes.
again, I have also gone through exhibit 8, issued on 22/12/2002. I were the dependents. It is dependent document. Showing correction of the fruit land. How it was corrected? That's the question. Fruit land was mutated in the name of the dependent. So very, very specific statement about that is a mutation. Now, look, if we go again, if we go to exhibit 8, what is the content of that exhibit 8? I have forgotten. Take it up again, right? No. Showing the correction, the fruit land was mutated in the name of the defendant. The specific about statement that it was mutated in the name of the defendant. Also, but why the correction was made? What led them to correct? I have found no supporting evidence on behalf of the plea of the defendant. The defendant's case is that it must be corrected. And accordingly, his subordinate with the WS is that he along with the plaintiff went to the office and asked them to get their name mutated. It's not their case that it was done in course of the settlement operation. I will refer the government made in the intention control. They probably just say so at paragraph 22 of the evidence. They did not work. Yes. I have found no supporting evidence on behalf of the plea of the defendants. So, when from the evidence and record, it revealed that the plaintiff's witness can prove by oral and documentary evidence that plaintiff is the owner of the land. This is fine. So according to him, it was a mutation. And what led them to mutate it is not very much clear. So the document which was issued as 17 need not be rectified again. On the evidence on record, it is also not disputed that the husband of the plaintiff died in the year 1989. This is very, very important. And this mutation was made, settlement was made in the year 1972 during the lifetime of the husband. It will be very, very difficult to believe that the husband is not aware of this fact that his wife has got his name entered in the revenue regulation. Everything is possible. A practical consequence is village ready. He is not, without taking his husband consent, went to the revenue office and made an application. And that application is made, numbered as 282 of 1971 and 72. And she was heard. And then purely the conversion was made and she paid rupees 45. All these things were done in the year 1972.
I can only hope that my wife sees this video.
Very difficult to do. That is a rural life. Not in the rural life, even in the urban life also.
I don't know. I just hope that somebody will look at this video today. Because in many things I am not consulted. Just take a break and come back.
That should be what man will. We did the country in 1972. That's what the friends.
No, if we can't lose faith on that system, because otherwise, no. You see, we can't lose sight of the fact that had this not been followed earlier, same practice, we would not have had Ramayana. If you trace out the history, you will find out that this is being followed in time immemorial. Just take a break and come back.
Page 49. He has applied his mind. From the evidence on record, it is not disputed that the husband of the plaintiff died in the year 1989. And since then, I have also found no dispute between the parties. But through the defendant evidence is that the premium of the stood land of rupees 45 was paid from the joint property. But in my opinion, it is also did not hold good when the documents reveal that the plaintiff is the absolute owner. Now, Lord, in this regard, straightway, Lord, I would like to refer his judgment.
Yes.
Yeah, 1998 Ford LT, Confusion. One thing is that when the
Yes. Yes, please continue.
Homabandi was prepared on the basis of the patta. And so for section 40 and 41 of the land revenue regulation is concerned, that must be considered as a correct entry, unless contrary is proved. Now, even if we assume that this land was my husband's land, or it was converted to a periodic patta, fact remains saying that I am the absolute owner of the land. And that has been reflected in the Jamabandi. Now, in that Jamabandi, some other names were included. Now, this inclusion can be done through mutation. And for the purpose of mutating person, there is certain provisions and you are to comply with that provisions. Without compliance of that provision, this mutation not be considered as a mutation. That is the specific holding of this High Court. Of course, it must be asserted that the mutation entries were done properly.
Yes.
If it is found that the mutation entries were not done properly and doubly got, if it is collusive and fraudulent, that mutation entries will not create any right. So here,
No, please continue. I'm hearing you. Ah.
I thought that you also.
No. Nowadays, we are in the age of multitasking. No, please continue. I am all ears.
So, reveals that learned appellate court had considered all the relevant factors which are essential to make a decision. What was the factor? The factor was that Jamabandi was issued in the year 1970. Second factor was that there is nothing to show that a mutation entry was made. Mutation process was carried out. Third was that what led them to do these things? Not- yeah. Fourth one is that during at that point of time, her husband, he died the year 1989. His entry was made 1970. Though it is not specifically stated in any word that a village lady, how this thing can be done. So all the relevant factors which require for a decision was duly considered. Now, my lord, in order to find contention before your lordships, like to refer one judgment.
Yes.
That is, if the KR, 1993, volume 3 SCC 722,
722.
722.
Yes.
Paragraph 4, 5, and 6 are relevant. May I read that?
Yes.
It has been noticed time and again that without insisting for a statement, for the statement of such a substantial question of law, the memorandum of appeal and formulating the same at the time of admission, the High Court have been issued and generally deciding the second appeal without adhering to the procedure prescribed under section 100 of the Code of Civil Procedure. It has further been found in a number of cases that no efforts are made to distinguish between the question of law and substantial question of law. The exercise of the power under this section, the findings of fact of the first appellate court are found have been disturbed. Has to be kept in mind that the right of appeal is neither a natural nor an inherent right attached to the litigation. Being a substantive statutory right, it has to be regulated in accordance with the law in force at that relevant time. The condition mentioned, the section must be strictly fulfilled before the second appeal can be maintained, and no court has the power to add or enlarge those grounds. Second appeal cannot be decided on purely equitable grounds. The concurrent findings of fact, however erroneous, cannot be disturbed by the High Court in exercise of the powers under this section. The substantial question of law has to be distinguished from the substantial question of fact. So they have quoted one judgment. The proper test for determining whether a question of law raised in the case is substantial would, in our opinion, be whether it is of general public importance or whether it is directly and substantially affect the rights of the parties, and if so, whether it is either open question in the sense that it is not finally settled by this court or by Privy Council or the federal court, or is not free from difficulty, or calls for discussion of alternative views.
Something is wrong. This is not coming up in 1993. You have given the right citation, 93 3 SCC 722. What is the citation? 1993,
No, 1999.
1999. Okay. Yes.
I read
Yes,
it again.
yes. No, not required. Not because I made my notes in the meanwhile.
The proper test for determining whether the question of law is raised in the case substantial law would, in our opinion, be whether it is general public importance or whether it directly substantially affects the right of the parties. And if so, whether it is either an open question in open question in the sense that it is not finally settled by this court or by the Privy Council or by the federal court, or it is not free from the directly or calls for the discussion of alternative view. If the question is settled by the highest court or the general principles to be applied in determining the question are well settled, there is mere question of applying those, or that the plea raised is palpably absurd, the question would not be a substantial question of. The paragraph 5 is very much pertinent. It is not within the domain of the High Court. Investigate the grounds on which the findings were arrived at by the last court of fact, that is first appellate court. Being the first appellate court is very much important there. It is true that the lower appellate court should not ordinarily reject witness accepted by the trial court in respect of credibility, but even when has rejected the witness accepted by the trial court, saying is no ground for interference in second appeal. When it is found that the appellate court has given satisfactory reasons for doing so, In a case where one given set of circumstances, two inferences are possible. That is very much important. I am not agreeable with the finding in these things, but I have to look into whether it is reasonable or not. Whether a reasonable person, well instructed with the law, can come to such conclusion. If so, then I should not interpret. Though I am not agreeable with the findings. In a case where from a given set of circumstances, two inferences are possible, one drawn by the lower appellate court is binding on the high court in the second appeal. Let me read it again. In a case where from a given set of circumstances, two inferences are possible, one drawn by the lower appellate court is binding on the high court in second appeal. Only thing is to be looked into whether it is reasonable or not, whether it is perverse or not, whether it is such that a reasonable person could from the confines of a reasonable person. It's not probably the binding which was assigned by the law should be accepted. One drawn by the lower appellate court is binding on the high court in the second appeal. Adopting any other approach is not permissible. The High Court cannot substitute its opinion for the opinion of the first appellate court unless it is found that the conclusion drawn by the appellate court was erroneous, being contrary to the mandatory provisions of law applicable, or its setting position on the basis of pronouncement made by the apex court, or was based upon inadmissible evidence, or arrived without any evidence. If this conclusion is without any evidence, if the conclusion is inadmissible in evidence, if the conclusion is against any judgment law on those how it can be interpreted. But in order to interpret, one must look into whether the judgment is passed with some reasons or not. If it is reasonable, then it should not be considered. So what is my respectful submission before your lordship, that while the first appellate court of fact had considered all the relevant factors, that is evident from the page 48. I have noticed that there was no such issue regard to the strength of Jamabandi, validity of the Jamabandi. The issues that the learned appellate court also considered the relevant issues by the trial court. So if your lordship goes through the issues that reflected at page 47, only 6, 7 and 8 are relevant. Whether the father of the plaintiff purchased and possessed the suit land of the plaintiff and whether the plaintiff has been possessed from the year 1950 continuously. Next, whether the plaintiff is the owner of the suit land. Now, whether the plaintiff is entitled to any relief and all. Now, because so far these Jamabandis and the Jamabandis are concerned, there is nothing. No issues were found. Till then, my lord, right of ownership may be inferred on the basis of the patta in favor of the plaintiff, the year 1972, which was reflected in the Jamabandi 72. And that Jamabandi has not been questioned by the defendant. And defendant case is that he need not question that Jamabandi because his name was entered the subsequent Jamabandi. And this entry was made on the basis of the request made by the state. And it is a finding of fact that it is a case of mutation. And mutation requires fulfill certain provisions as envisaged under the land revenue law. And there is nothing before. The other day, Lord, I argued one point to the Industrial Act as well as the Executive Act. I wanted to draw my contention through Article 298, whereby the property country respect to a citizen. For that purpose, Assam Land Revenue Regulation some provision, makes some provisions. And that provisions contain from section 21, on that day I have referred. Probably a lot of again by repeating all. Certain provisions were made. According to that provision is settlement of fire. One of that provision is the settlement of fire. The procedure as contained in the settlement operation are to be fulfilled. Only after fulfillment of the procedure contained in the settlement operation, settlement officer shall make an offer to the person concerned that they are interested to, they would like to offer to grant a settlement, their favor. And the person concerned shall confirm that whether he is agreeable to accept it or not. Mere offer and acceptance will not create any right, title, or interest. It has to be approved by the government. And only after approval of the government, then and only then, this settlement can be granted in favor of the person concerned. The grant of settlement has to be reflective of the Jamabandi. And the Jamabandi as per section 40 and 41 of the Assam and Land Revenue Regulations, is Jamabandi, the entries made in the Jamabandi are presumed to be correct. So it must be presumed that a patta was granted by name, unless the contrary is proved. The defendant has not made any attempt that no patta was granted. Their case before your lordship was that not in their view is that the defendant, the plaintiff, filed an application before the revenue authority, which was numbered as 282 of 7172, And after payment of these things, this was granted to him. Now, one thing that I would like to distinguish, that the grant of patta is an executive act, and for the subsequent rectifications or subsequent entry, that is mutation, etc., are the ministerial act. So far the executive act is concerned, grant of patta, and that is fortified by these judgment also. Paragraph 7. Under the Assam Land and Revenue Regulation, to be a landholder and has a permanent, heritable and transferable right use of the occupancy, and his land is subject to section 19 of the Assam Land Revenue Regulation. If a person, in order to establish his project and his title, produces a patta, that must be given weightage in as much as patta issued in accordance with the provisions of the section 17, read with the rule, must be considered as a document of title. So this document is far, far above than the mutation entry. Now look, so far the mutation entries are concerned, that's the revenue entry. Mark return should not be given. Yes, it is correct that must be considered, it should be brushed aside, but much return should not be given. For that purpose, below, one thing that the court has to consider, that the mutation was carried out in accordance with the law or not, set down in this behalf. Second thing, that
What will be the Assamese of Assistant Settlement Officer? Assamese word of Assistant Settlement Officer. উপসহায়ক বন্দোবস্ত অধিকারী উপসহায়ক
বন্দোবস্তি বিষয়া
বন্দোবস্তি বিষয়া।
first word
সহায়ক হ'ব
সহকারী assistant is a সহকারী
সহকারী বন্দোবস্তি বিষয়া।
okay, that's all. Anything in reply, Mr. Mazumdar?
10 minutes.
You want to do it now or 2 o'clock?
Let me do it 12, 2 o'clock so that I can.
You give these paragraphs. Paragraph.
I've confined my reply to the pleadings and the judgments. Because my lord, after the various surveys made in the various provisions of the the regulation, then rules. What I'm reminded of one video, my lord, I was just watching for them. Suddenly the volume also became very high. One Mr. K.K. Muhammad was the archaeologist. The Babri Masjid, he was the main archaeologist. Pursuant to the judgment passed by the Supreme Court and the action by the Supreme Court, there's one video. He said, I just watched the other day. He said, I'm not concerned with any religion. He is K.K. Muhammad. He says, I'm not concerned with any religion. I am concerned with only survey. So initially, people made some announcement that only the remnants of a mosque was found. But my duty was to dig and find out the truth. I am only on truth. And when I go deep into it, I find that there are 18 pillars of temple. He's a Mohammedan. He says, no, it was there was a temple earlier. I'm saying only from video. I'm not making a statement from my side now. In this case, we find as we go deep into it, I don't know ultimately where we will be led to. But then I'll make my submissions on the basis of the pleadings and I'll be very brief. 10 minutes I'll take.
Fair.
Was not good. Anyway, you take it. So we are lots of meticulously gone through. But then after,
No. You know,
at the second time, I
Yes.
should give the fair.
there is something called which is what you call meticulous reading, and there is another thing called a facade of a meticulous reading. I do the second one.
Only the facade.
Huh?
Only the facade. Front side.
At two. I have restored this chair.
May period.
One judgment that I have not read. 96.
Exactly, he said.
Copy is not with your lordship.
No, I have it.
No. The First Appellate Court judgment is very simple and reversing all the findings of the trial court. In fact, there's now discussion about the trial court's finding. It's a very short judgment without recording any reasons for reversing the judgment of the trial court. On issue number 6 and 7. The finding is very simple, that settlement was in the name of the plaintiff, and subsequent correction of the mutation by for insertion of names of all the persons, including the present substituted plaintiff, is incorrect, because patta was issued in the name of the plaintiff. And on the basis of this observation only, all the findings of fact recorded by the trial court, particularly when the trial court has a recorded finding that admitted fact or the plaintiff herself, fortunately the plaintiff herself was alive and she has deposed, and she herself has very clearly, in clear terms, admitted that land was purchased by her husband, who is the father of the present appellant. And at the time of settlement, the premium was also paid from the fund raised from the cultivation made in the land belonging to her husband, that is Jainarayan Upadhyay. These are the findings based on which the trial court found that the mutation correction was made and insertion of all the names, including that of the plaintiff, was correct. That was the finding of the trial court. All this were discussed, and there is no discussion as to whether these findings are correct or whether findings are perverse by the first appellate court, but it has been reversed. The ground of reversion is, since this settlement was in the name of the plaintiff, there is no right in favor of the appellants. Now, Lordship will find that if we go by the submissions made on behalf of the respondent, that we have to see whether the mutation correction or mutation in favor of all the persons were correctly made or not. If that is the case, and if that is taken along with para 14 of their plaint, it is actually case of challenging the mutation. Although they have prayed for declaration of title, but they have actually framed the suit, and the substance, in substance, the suit is challenging the mutation in favor of all the persons. And my submission will be that prayer is hit by section 147 of the Assam Land and Revenue Regulation, because appeal lies against that and no suit will lie. Secondly, my lord, I'm grateful to this honorable court. I also missed that point, that in fact the name of the plaintiff korton kora hoise, name of the plaintiff was already removed from the record. That removal, korton, was never challenged. And Lordship will kindly see one thing here, that section 32 of the, Rule 32 of the settlement rules framed under the Assam Land and Revenue Regulation. It says, I'm just in brief, I'm submitting, it says that person who is in possession of the land will be entitled to settlement of the land. Your Lordship is aware of that. I'm just pointing out for my benefit, my lord. Lordship, may kindly have a look at Rule 32. Lordship has got my lord, Rule 32. To whom settlement is to be offered?
Oh,
Lordship has got my lord, Rule 32.
Rule 13 is conversion of annual lease into periodical lease.
My lord, Rule 32 is
32. Oh,
Ah.
I'm sorry, I'm reading 13.
maybe I should be sorry.
No, no,
It is
32.
Section 32. I'm sorry, madam.
No, no, no.
Yes, I'm sorry, miss. I'm wrong. Section 32.
It's,
Not
uh,
not rule.
ah.
I'm sorry. Yeah.
Huh.
Chapter 3
Yes,
deals
yes.
with settlement and resumption, and section 32 comes under chapter 3. It says to whom settlement is to be offered. Settlement officer shall offer the settlement to such persons, if any, as he finds to be in possession of the estate and to have a permanent heritable and transferable right of use and occupancy, etc., etc. Now, Lordship will kindly see one thing. Admittedly, the land was purchased, possessory right of the annual patta land appearing in the name of one Medanidhi Sarma was purchased by Jainarayan. It is an admitted fact. Now, if Jainarayan was in possession he died in 89. If he was in possession in 1972, the settlement should have been offered to him. That means the plaintiff or maybe her daughter, who is now still fighting, they have done the mischief. Settlement itself was wrong. So in order to correct that, my lord, immediately on our application, and we have specifically pleaded, and in the evidence I have just now checked up, my lord, although there is a suggestion, but then in the evidence also, oral evidence also, I have supported that pleading. That subsequently, what has happened, my lord, factually, 72 the settlement was made. 1996, the daughter of plaintiff Bhagirathi,
Yes.
by making an application, brought her name in and cancelled the name of her mother.
Yes.
Now, 1996, 72, sorry, settlement. Settlement is in 72. 1996, she brings her name, removing her mother's name. And then 2002, the correction was made. And the correction that was made in 2002, our pleaded case is that when we came to know that she has brought only her name by removing her mother's name also, and we for the first time came to know that only in her name it was done, all of us went, all of us, including the plaintiff, all of us made application that names of all the persons should be brought in. That is how it was brought in. This mischief was removed by 2002 correction. Now, when an argument is made that mutation record doesn't confer any right, doesn't create or extinguish, it is not a case where I am praying for a declaration of a title on the basis of a mutation which was done without any basis, without any sale deed. It's not that case. Here the case is absolutely different. That is why, my lord, the judgment which says that it should not be ignored. Here, this is the fit case where it should not be ignored, because in the background in which the correction was made shows that a correct decision was made and correct position was restored. It was in mother's name. Mother also did it in a mischievous way, because at that time father was alive, and in terms of section 32, settlement should have been offered to the father. So in order to rectify all these things, a joint application was made, and quite rightly so, in order to bring the names of all the persons, and justice was done. Now you are saying that I am challenging this mutation. If you challenge this mutation, first of all, if you have never challenged, now you are challenging the suit is barred. There are plethora of judgments of our High Court that this kind of suit is barred. And in those judgments, since there are prayers for, there is an indication that if the suit is for declaration of title, then the suit will lie. Otherwise, it will not. But here, in substance, it's a suit challenging only the mutation entry and nothing else. Declaration of title is sought on the basis that once the court declares the mutation to be bad, then I have title. So, my lord, in view of this, the judgment and decree passed by the learned first appellate court is bad in law. It is illegal exercise of discretion, and therefore it should be, the appeal should be allowed, and the judgment and decree passed by the trial court should be restored. And my lord, the substantial question of law should be answered in favor of the appellant. One judgment my learned senior colleague has referred about the section 100 of CPC, my lord. I'm referring to one particular judgment. I'm troubling your lordship because I didn't give any list. Also, 2019 7 SCC 641. 2019 7 SCC 641, Gurnam Singh versus Lehna Singh. Please got ma'am. Lordship has SCC also.
In fact, uh, there is
Nowadays, my lord, I have noticed one thing. The Supreme today, they have made their paragraphs in tandem with this SCC also. So that paragraph nowadays tallies, I have noticed. In some judgments. In earlier judgments, it did not tally. Now it is tallying.
no. What is happening is this question I have raised at the highest level, even with the law minister, even with the Solicitor General of India,
Prime Minister, India.
as well as with this Supreme today people. The information which I could gather was that there's a judgment of Supreme Court where SCC online has been given protection of its paragraphs and the head notes. Copyright has been given. So what they are doing is that the original judgment, let us say, contains 5 paragraphs. Supreme today will break it up in 7 paragraphs. No, SCC online. They will break it up in 7 paragraphs. So SCC will have 7, but AIR and the Supreme today, they will be having the original paragraphs. And in many cases, I have flag marked with them. I also subscribe to, it's my personal subscription. I still take STPL. So Mr. Sanjay of STPL also came. I posed him the same question, and they informed us that they are following the Supreme Court judgment verbatim. And they have shown me those few of the paragraphs, few of the judgments where I had flagged that it is not tallying. For example, in a given case, one paragraph was 91, and in the SCC it went to 106 or 7. So I just couldn't follow it. And they produced me from the Supreme Court website the original judgment, printed out in my chamber and then showed it to me that this is the problem. Then I even spoke to people who should know about it, that how can a Supreme Court judgment be tinkered with? Supreme Court full bench gives a particular format and the SEC is changing it. You will find in cases of larger bench, where let us say there is a constitutional bench or a what you call full bench Supreme Court judgment, where the where the senior judges give a dissenting view and the junior judges, the puisne judges, they take a different view, and that is the what you call the by majority judgment, what we call puisne judgment is a wrong word. The majority judgment is by the not senior judges. In SEC, the format is that they will place the of the leading judgment at the top.
Yeah.
And yes. So the majority judgment will come first. And therefore the problem is that we can't reconcile when we are when you are placing SEC and I am reading from Supreme today, irreconcilable. So I have spoken to people who should know about it. And they said that since the Supreme Court has protected it, they are unable to address my grievance.
There are reasons.
I had followed it up, but I was unsuccessful.
Then effort has been made, find out. What is
Yes, because you see, you are citing just like in the last judgment, Mr. Dasgupta was citing me paragraph 7. In my copy, it is paragraph 9. So it's very difficult to follow.
The paragraph mentioned,
Ah.
then it has been mentioned from where?
Ah.
That becomes the question.
So in few of the judgments, the precedence is the larger bench judgment, and therefore we are not unable to follow it in many cases.
But I have noticed one thing today, when they quote a particular paragraph from another judgment, that paragraph again, that paragraph number again, tallies with the SEC.
That may be because I've not checked it, but yes.
Check that once or twice.
But that is why after, in the meanwhile, when this query I was posing had been circulated at some places, in fact, from prior to it, the Supreme Court had taken up the cases of neutral citation. Neutral citation. Now, in every recent judgment which you will come across, you will find that there is a neutral citation of the Supreme Court itself. Supreme Court itself gives a citation. It's being followed by many high courts. We are just lagging behind, but a few other courts have joined in. They are giving their own citations. So therefore, if you look at a recent, you can open up any recent Supreme Court judgment. '22 onwards, mid-22 onwards.
Since the online.
No. Now there's, you'll find a Supreme Court. What is it? What is it coming? The citation?
Opening. Supreme Court,
Huh. In the top, along with the AIR and all, this neutral citation will come.
Once it says 2023 0 INSC 1080.
Yes. So this is a neutral citation. So now from neutral citation from the Supreme Court website, you can find out the original one while you are referring to SEC or any other journal.
Yes, all are INSC.
Ah.
That means
So-
it stands for maybe Indian National Supreme Court or something.
Ah.
So it's
India
actually
is IN, I is India,
India.
Indian Supreme Court. So INSC.
In between N is there, maybe national.
India, IN.
I
IN is
there.
India.
Yes. This is a neutral state.
Ah. So this is now by a judicial pronouncement, this is made mandatory. So in order to,
We
uh,
will have any copyright now. Citation by the court.
by the code itself. And now we are also following it. Will be able to do it in this year.
Well, I was referring to this,
Just before that, I'll tell you that the citation which the principle which has been cited by Mr. Dasgupta, that you will find is a full bench, sorry, Constitution Bench judgment of Supreme Court of India reported in AIR 1962, Supreme Court, Chunilal Mehta.
that is the first case.
So there, that principle has been laid down and subsequently it has been followed, but this is the original judgment. Huh.
Well, these judgments here, of course, Chunilal is not mentioned, but then Pachugopal has come. Pachugopal has mentioned of Chunilal. Pachugopal, then Ishwardas Jain also is there. I am only reading one paragraph, my note, this is paragraph 19.
Yes.
Before parting with the present judgment, we remind the High Courts that the jurisdiction of the High Court in an appeal under Section 100 CPC is strictly confined to the case involving substantial question of law, and while deciding the second appeal under Section 100 CPC, it is not permissible for the High Court to reappreciate the evidence on record and interfere with the findings recorded by the courts below and or the first appellate court. And this is important. If the first appellate court has exercised its jurisdiction in a judicial manner, its decision cannot be recorded as suffering from any error either of law or of procedure requiring interference in second appeal. We have noticed, and even as I repeatedly observed by this court and even in so and so, despite getting out this, etc., mandate of Section 100 are disturbing and so what I'm saying is, my lord, the first
That is a, what is the name of the judgment? Gurnaam Singh.
Nothing versus.
So what I'm saying is, my lord,
Lehana Singh,
Lehana Singh. So what I'm submitting, my lord,
1976 school.
taking aid from this judgment, my lord, is that in this case, the trial court's finding of fact recorded on the basis of evidence on record was reversed by
That was paragraph.
paragraph 19.
At page 652.
Yes.
Taking aid from the judgment, my lord, my submission is the first appellate court has reversed the finding of the trial court by exercising the discretion not in the judicial way. That is why is liable to be interfered. That's all.
Bhasi.
Like to complete.
না না মাটি দিব
Oh, still.
Both sides are represented. And so the submissions of Mr. A Das, senior counsel, assisted by Ms. B Das, counsel for the respondent, is concluded. The submission in reply by Mr. D. Mazumdar, senior advocate, assisted by Mr. P. Bora, counsel for the appellant, is also concluded. Judgment reserved. So you reminded us of Chiman Lal. He also remembered it. He has, despite being advocate general, he has additional advocate general. He has kept his what do you call skills sharpened in this civil side also. No, that's not denying, but he has kept his civil, he has kept his civil side sharp.
But there is a connected schedule also. So that is the second case.
It will be same. It will be same. The second suit is
Not, once your lordship is aware, I'm trying to remind you, once your lordship is aware, no problem.
this the difficulties with it, yeah,